First of all, there is actually no common agreement on what the problem is. Secondly, as has been mentioned, there is no what I would call legally instructive definition of the key terms. It's very unwise to negotiate an international convention which is designed to shape law without there being certain technical clarity about the terms that are to be discussed. And finally, there is no common agreement on the mode, the means by which the commitments are to be delivered. Now, in all this, there is, I think, a basic problem with the ABS CBD debate. You will have noted from the introduction that I have a deeper background in trade than these issues, but at the APEC Centre we began some research on the CBD issues about 4 years ago, and I had approached the CBD with the presumption that this was a convention, an environmental convention to protect biodiversity. Yet in fact, when you examine the ABS elements, they're not environmental, they're economic. And the aim of the ABS measures is to secure economic gain for the state. Now, if you think that's not what it's about, review the proposals that are on the table, understand the debate, and what is very clear that among the key proponents, the objective is to secure for the state ownership of the genetic resources. And this is one of the reasons why making progress in this area is quite difficult, because it has actually nothing to do with the core purpose of the CBD, which is to protect biodiversity, unless one believes that the only way to protect biodiversity is for the state to control the economic benefits of biodiversity. Now, this is an issue which is not much discussed, but it is core to the discussion. It is what defines the differences among the key players, and unless that question is addressed, it won't be possible to reach agreement. So as I say, until this is recognised, the debate is going to remain incoherent, and quite frankly, when you look at some of the documents and read some of the statements, it is incoherent. There are things that are said which actually don't add up, and it's because there are several different issues being discussed at the same time. Now, there is an ambition in the CBD negotiations, and let's just see what that amounts to. There are several levels of proposals on the table, but there is a reference point, if you like, on the table, and that is a specific proposal for a treaty on access and benefit sharing which does the following things. Create rights for governments to nationalise genetic resources. Dictates the terms of exploitation of those genetic resources. Extracts rent from their use and development. Limits the application of the norms of protection of invention. Now let me repeat that, limits application of the norms of protection of invention, because when you look at some of the provisions, they say quite expressly rights to patents will be restricted under certain circumstances for access to genetic resources. That's not an accident, it is a clear political intent. It's a big intent, and yet that's one of the things that is on the table. And finally, the reference point, if you like, seeks to control the terms of delivery of the benefits. This is a very dramatic economic control instrument. It in fact runs contrary to really what is established conventional approaches for economic cooperation in most of the rest of the international multilateral system. And the significance of this, I think I'm putting this very boldly, but if you want to know why the debate is complicated, about why the differences are wide, about why not much progress is being made, these are the core issues. So let's look at the key features of the debate. The leading proponents of this reference position, if you could call it that, are Brazil, India, the African group has played quite a leading role. Now there are some other delegations, but in the evolution of where things have run, the strongest positions tend to have been expressed from this group. There's a second key element which Brendan made reference to, which is a reference to Article 8J in the Convention, and that is that there is now built into the approach the necessity for protection of traditional knowledge. Now, the presumption in the what I'd call reference position, the harder line draft proposal, is that the grant of right of access to traditional people is actually proposed at the behest of the state. Now, this is an interesting question which I'll come back to, because much is made of the question of the rights of traditional people. There's a very simple answer. Some of it has been alluded to. So the key features, as I say, of what I call the demandeurs model is state control of genetic resources. So in our discussion here, I've been asked to address, are the proposed ABS mechanisms meeting CBD objectives? The question to ask, therefore, is does this model improve access to genetic resources and provide greater gains to the owners of genetic resources? That is, after all, the point of the ABS, to improve access and provide greater gains to the owners. Well, what's the justification for putting forward this new radical regime? First, biopiracy has been mentioned, and we hear again and again and again that the treaty is designed to protect against and prevent biopiracy. Secondly, it's to protect against misappropriation of rights in two areas. First, under IP law, and secondly, of traditional knowledge. Now, when we began research in this area several years ago, we looked at these things and we found that there is a pretty fundamental question to ask. And that is there misappropriation of rights? We looked at all the cases under IP law, and our assessment is that there are no cases where good IP law is at fault. And we went through every case that was supposed to be an example of biopiracy, and we found that in some cases IP law had been misapplied. In some cases a patent had been granted when it shouldn't have been under good IP law, where some trademarks have been granted where they shouldn't have been. There have been challenges, they've been removed. What it revealed is that there seemed to us to be no systemic flaw or weakness in the IP system. There may be an issue about information, which is a different question. That doesn't warrant very dramatic changes to IP law. And then on traditional knowledge, we found a very curious result. Very few countries grant property rights to genetic resources in traditional knowledge to traditional people. Now, we have had some examples cited to us in my own country. There is a model for providing for bioprospecting. It's in the state of Queensland, where there's significant land rights accorded to traditional people. Bioprospectors may not bioprospect without getting a licence under law. They are obliged under that law to consult traditional people. They are required to negotiate with them, and the bioprospecting contract requires them to recognise the property rights of the traditional people, and then arrangements are negotiated, very similar to the sort of examples we've seen both in Costa Rica and in Thailand. Now, once the traditional people have acquired a right to the property, then the terms of benefits to be derived later can be settled at that point. And that's the natural place for providing rights to traditional people. What is interesting, if you review countries where traditional people have a significant role, few provide property rights for traditional people. And that would actually be a very good starting place to deal with the problem of traditional people. So let me share with you what our conclusion was on this. There is no biopiracy. Now, this is considered to be a controversial position, but I'd be willing to say to anybody, show me the case where it is. I say we've been through all of the cases, and a biopiracy means an illegal acquisition of someone else's property. There is no evidence. So, if we're going to have a legally binding ABS regime, and that is